Your Honour, my name is Colley, Colley, initial H, and I appear for the defendant, Amigone Cremators Proprietary Limited. I'm instructed by Herbert Smith, Freehills. Your Honour, my client is counterclaiming to estop Burns Ever After, the plaintiff, from denying purchase of the coffin coaster and ash processor. My client also wishes to contest the claim by the plaintiff that there was any misleading or deceptive conduct regarding the representation of the $85 cremation cost. The information in dispute is in relation to the $85 per cremation for which my client gave estimates, which were based off long-term projections and expected costs. The representations made were based on similar machines and over long-term performance data. The statements made were to encourage the other party to enter the contract and were not enforceable obligations under the contract. Unlike the case of J.A. and J.B. Boyle Proprietary Limited against Major Furnace Australia Proprietary Limited, the plaintiff did not enter into the contract with my client as a result of the cost estimated provided by my client. The plaintiff was encouraged to enter the contract with my client, a local supplier, in order to receive the goods quicker and to have technical support at arm's length. My client delivered and successfully installed the BD60 at the plaintiff's premises within the agreed upon time frame and offered the plaintiff additional technical support from my client when it became apparent it was needed. As per Section 18 of the Australian Consumer Law, mentioned in the Boyle against Major Furnace case, my client did not describe the performance of the BD60 to Mr. Evelyn with the intention to mislead or deceive him. My client did not have a duty to give exact estimates. The estimates made were of his opinion, and both parties knew this, as per Bissett against Wilkinson 1926. My client relied on the information provided by the plaintiff. The plaintiff did not indicate the exact usage patterns associated with these figures as to whether the cremations would be performed in bulk on one day or in systematically spread out fashion. There was no failure to provide accurate information as the long-term projections were not given the chance to be demonstrated in use. The plaintiff's losses were due to other factors not specific to the equipment. Rescission is not possible as neither party can be returned to their position prior to the commencement of the contract. The equipment has now been destroyed due to the plaintiff's inadequate storage. The defendant accepted a large reduction in the price to have the plaintiff purchase further equipment, as promised. My client has already suffered a substantial financial loss which cannot be repaid or returned in its original condition. The consumer cannot reject goods under Section 2623 of the Competition and Consumer Act 2010(b) if the goods have been lost, destroyed, or disposed of by the consumer. In the pre-contractual case of fraudulent misrepresentation of Aladi against Kruger 1955-94 Commonwealth Law Reports, it was cited that in equitable rescission, the court makes decisions on the validity of the act of the party contesting the contract. Aladi argued that rescission of the contract was not possible as the shop no longer existed, and under common law, Kruger could not rescind the purchase as he could not return the shop in the same way he received it. However, in equity, as he could not be found to have done anything unconscionable to prevent the shop making profit, the court found he did not have to continue business. As stated in Aladi, a purchaser who elects to rescind is obliged to take reasonable steps to preserve the property and return it to the vendor and to not abandon it. As per Henjo Investments Proprietary Limited against Collins Macroville Proprietary Limited, discussed what a reasonable person should have done to mitigate the loss. The plaintiff continued using and profiting from the equipment and did not attempt to return the item within a reasonable time. Similar to Henjo Investments, where it was nearly a year before any clear demand of rescission was made. In this case, the plaintiff also waited many months and never attempted to return the BD60. It cannot be found that there was a major failure under the Australian consumer law, as the goods did not have a major failure, and they are not substantially unfit for purpose. They are not dangerous or significantly different from the description. My client did not meet any elements of misleading or deceptive conduct under Section 18 or Section 4 of the Australian Consumer Law. Unlike the case of Boyle against Major Furnace, the plaintiff did not formally request a refund or try to bring the contract to an end within a reasonable time. The plaintiff continued to utilise the machine while refusing to engage with my client's technical support staff for repair. Therefore, rescission cannot be ordered under common law, as no evidence of fraud can be shown. My client wishes to uphold the promissory estoppel in which the plaintiff made a promise to purchase the coffin coaster and ash processor and is now trying to withdraw from that representation. The promise was made clear and unambiguous. My client requests an injunction ordering the party to honour their promise. The plaintiff took an undertaking to purchase the coffin coaster and ash processor after 6 months of successful installation of the BD60, and my client offered a $45,000 reduction on the cost of the already reduced price of $165,000 to secure this agreement and commitment. Undertakings under the Australian Consumer Law are enforceable. The BD60 was successfully installed within the 13 weeks as per their agreement. Similar to the case of Jones v. Dumbrell, 1981, Victoria Law Reports 199, the plaintiff was aware that my client would reduce the price with the promise of further purchases and use that to secure discounts. The plaintiff was able to negotiate on favourable terms due to this promise. All 6 elements of equitable estoppel were met. The plaintiff made representations to purchase further equipment to receive a large discount on an order. The plaintiff induced my client in relying on the representations, and my client relied upon the representations and acted by reducing the price, which showed reliance on this promise. The plaintiff knew my client was relying on the promise, and my client believed that they could safely rely upon the representations, and the plaintiff intended my client to rely on these promises. My client's reliance on the promises has resulted in a detrimental loss of profits due to the much lower price which was discounted to the plaintiff. The plaintiff did not act to avoid the detriment and led my client to believe he would honour the promise, and at no point did they mention they were going to rescind from this promise until after the promissory date expired. It was found in Waltons and Maha, 1988, 164 Commonwealth Law Reports 387, that inequity would intervene if the representer's action went against promises made in the form of non-contractual representations, if it would be unconscionable for the representative to go back on their word. Your Honour, I conclude that there are no grounds to the claim of misleading or deceptive conduct regarding the cremation costs, and the contract should be upheld. The product has now been destroyed and cannot be returned. We wish the court to uphold my client's counterclaim to stop the plaintiff from not upholding their promise to purchase the coffin coaster and ash processor, or compensate my client for the losses incurred as a result of their reliance on the representation. It would be inadequate to allow the plaintiff to later change their mind after my client relied on their representations.